Hi, everyone. This is Jill Baxter. And today on Board to be a Sports Agent, my students are going to talk about the Pavia case. There currently are 41 cases out there on this issue of eligibility and whether college students should be able to get years back and exclude their junior college playing time. So I'm going to let them start. There's a lot of information, and I really think this is going to be valuable and amazing.
Hi, so our group is called Beau Elite Sports Law, and my name is Solina, and then I'll quickly introduce my other students, classmates, Gary and Brian. And today we were given a scenario, and so we're gonna go over the scenario we were given, apply it to Pavia, go over for, against, and the school's position, and what we would potentially give legal advice on. So the scenario is as follows. We have a player, he's played 2 years in junior college. Freshman year, he transfers to a D1 school. He plays, then he gets hurt, he redshirts. Third year, he plays his senior year, starts, he has a good season. He's applying to the compliance department for another year of eligibility. With this scenario in mind, we were tasked under the Pavia case, do we think that he can get another year of eligibility? What arguments would be made and what arguments school will be made and what arguments NCAA is gonna make. So I'm gonna pass this on to Brian and he's gonna discuss the Pavia case because that will be in regards to influence our legal advice to this scenario.
So a quick little background on Diego Pavia. Diego is a football player from the state of New Mexico. He was a 3-star athlete in high school, went to a high school called Volcano Valley, which was a 6A school. Was a really good athlete, and his senior year led his football team to the 6A state championship semifinal. And even with all those accolades, he still did not receive a single Division I offer to play football. So in 2020, Diego took his talents to a junior college, the New Mexico Military Institute. And then in 2020, COVID happened. And so this is really the genesis of a lot of these arguments was the NCAA gave a blanket rule in 2020 for COVID, allowing pretty much any student to either transfer anywhere, but also gain an extra year of eligibility. And that included everything from the NCAA. Diego played 2 years at junior college, and in 2021, he actually won the championship for the New Mexico JUCO team. He then took his talents to New Mexico State. He had a pretty mediocre career at New Mexico State, caught fire in his second year, and ended up playing a bowl game. His offensive coordinator at the time transferred to a school called Vanderbilt, and Vanderbilt is an SEC school, quite an upgrade from New Mexico State.
It was head coach went to Vanderbilt.
Head coach and offensive coordinator,
Both
correctly.
Okay.
And if you know anything about Vanderbilt football, they haven't had a decent quarterback since Jay Cutler, which was a long time ago. And so Diego took that opportunity to go to Vanderbilt. And in 2024, to a lot of people's surprise, he had a breakout season, ended up upsetting the #1 team, which was Alabama at the time. And the issue for Diego at this time was he had used his eligibility, which is the main point of a lot of this argument, which is the 4-season rule the NCAA puts together. So you're allowed to play 4 years total in the NCAA. So
You have 5 years to play 4.
5 years to play 4.
Yeah,
so he
red shirt or whatever.
2 years in JUCO, the 2 years in New Mexico. He played the year at Vanderbilt, and so he at that time filed an injunction to give him 1 more year of eligibility. The federal judge granted this preliminary injunction, and the main argument for the injunction was the Sherman Act. So Diego's argument was that he, in essence, should have the equal opportunity to make the same kind of money in the NIL that all other 4-year NCAA players have that opportunity. He got to play that extra year, and Diego Pavia actually took Vanderbilt to the football playoffs and was a runner-up in the Heisman Trophy ceremony. NCAA actually appealed this injunction. The NCAA lost, really a moot point at that point because the season had already started. The NCAA actually caved in. And so then at that point, Diego Pavia has now petitioned for a 6th year. And he has filed a class action suit against the NCAA. There's a few other players that have joined in on that. And that's really where the case stands today. And so the class action is really targeting 3 bylaws: that 4-season rule, the JUCO counting rule, which is the 2 years of JUCO counting towards the 4 years of football, and then also the 3-year transfer limit, which really caps JUCO transfer to 3 years. So that's where it stands today. And so really the NCAA and all of this has a few different arguments, 3 to be exact. The first one is the JUCO rules. It's a legitimate rule. It's been in place for a long time, and it's worked. If it's not broke, don't try to fix it. It's kept standards in place and really helped the JUCO program be an opportunity for kids to play football, and really kind of keeping away from a semi-football league. The second argument is really the JUCO rule promotes competitive balance and really prevents manipulation. We allow students to play 6 years of football. Potentially, you're going to have powerhouse schools that have deep pockets, kind of using these JUCO schools as, I don't know, so it's stockpile older players, kind of have a, minor league system with some of these JUCO schools. And really, if you get rid of this JUCO rule, you're going to destabilize the competitive balance that all conferences have. And so the idea with the NCAA is to make all schools have some sort of competitive agreement. And so if this JUCO rule gets changed, you're going to have the larger schools with the deeper pockets receiving a bigger benefit. And then really a third argument is something that we've talked about on these other podcasts, which is the Texas redshirt rule or Texas redshirt kind of phenomenon. So a lot of parents are pulling their students either in kindergarten, pre-K, I guess the Super 8.
The Super 8th graders.
So you're keeping these kids back a year. And in essence, most of us know that boys mature slower. And so you give these boys an opportunity for their bodies to mature more opportunity in the weight room. And so you can have a big age difference, right? Starting senior year of high school. And so for myself, I graduated at 17 years old, and 17 to 19 is a huge difference in terms of maturation, body development. And so then potentially if you take, you have that JUCO, or you have that 19-year-old football player that his parents have been working towards and kind of prepping for a football career, putting them in a 2-year JUCO program to even get bigger, get built more, develop his skills. You then potentially have a 21-year-old freshman playing against an 18-year-old, 4-star, 5-star recruit that didn't go the JUCO route, that went the traditional NIL route, got a big offer. And if you're a 5-star, 4-star recruit, you're going to play as a freshman. And so you have this big age discrepancy that's already happening. And with the big money from the NIL pouring in, I think you're going to see this phenomenon happening even more. And so you're going to see even more parents keeping their sons back. And so I think those are pretty much 3 great arguments that the NCAA can make. You also have the opinion of the 6th Circuit, which dismissed the NCAA appeal, but for the most part, the opinion really just stated that the courts should stay out of NCAA rules. And
Oh, do you think that's why the judge ruled that way?
yeah, no, it said in his concurrence that, for the most part, the judicial system is really for legal matters, and they really want to keep that separation of powers. And so, yeah. He also made a comment about the Sherman Act, where the Sherman Act, the main purpose of that is equality for opportunity to make money. And so keeping the JUCO in place doesn't keep the opportunity away from anyone, just kind of a shorter duration. And so, the idea for the judicial branch isn't really to make new laws, but kind of keep it this. And so I think those 3 factors, and the NCAA has some really good arguments. So I'm gonna pass the mic to my friend Gary here.
Okay. Gary, are you gonna be advocating for the student?
Yes, I'm gonna be advocating for the student.
Okay,
Essentially, the student in this hypothetical is gonna make
Yes.
a lot of similar arguments that Pavia in this case.
yes,
Well,
that's why I gave you that scenario.
right.
It's 2 years of JC, transfer to Division 1,
Exactly.
maybe a medical year, and then played a year.
Pavia
So they played 2 years, even though they really played, they were out of college for 3 years, but they had one redshirt as a medical redshirt.
And that redshirt it allowed them to extend the time also, allowed them to get bigger and stronger.
Right,
So Pavia, as Bryan had mentioned earlier, spent a year at the New Mexico Military Institute, which is a junior college. Then he transferred over for 2 years to Mexico State and eventually went over to Vanderbilt University. And we're saying that the student's going to make very similar arguments. So essentially what Pavia wants to argue is that he wants to maintain the status quo with grant eligibility and that JUCO rule should not apply, allowing him to play for a longer time. So what Pavia is arguing is that NCAA rules are a violation of the Sherman Antitrust Act, which essentially protects fair trade by preventing monopolies. So the Sherman Antitrust Act does not prohibit every restraint of trade, only the ones that are unreasonable. So in this case, allowing him to continue to play will still be profitable for the school. Essentially, it would be unreasonable to limit athletes' eligibility into the college football level, and it would be unreasonable to equate JUCO's eligibility to the NCAA when name, image, and likeness opportunities are only available at the NCAA level. Name, image, and likeness money only offers players exposures for endorsements and off-field work opportunities later on. So the opportunities that Pavia and our student in this hypothetical, what they would receive, would only be limited to NJCAA and not the typical NCAA standard. That's the issue.
only limited to what?
The Junior College Association.
Okay,
So Pavia and the student will still get to play the sport that they really enjoy, that they're passionate about. They take more time to get bigger, stronger, and faster, and be with their peers. Doesn't harm anybody. The NCAA will argue that it wants to protect future athletes, and Pavia, and our hypothetical student, will say that we're doing exactly that by not counting the JUCO years, allowing them to play longer and to segue into professional level and getting those NIL opportunities later on down the line. And essentially, the NCAA will say that this is restricting the economic opportunity in the college athletics marketplace, but essentially the pro athletic marketplace later on down the line is so much more lucrative and beneficial to student athletes in the long run. I'm going to talk about a little bit divisions and opportunities now also. So if Pavia were to win the JUCO season will not count towards the college, meaning that Diego Pava can play another year of college football if he wants to.
right,
So the athletes are arguing that the time in junior college should not count against the time that they're allowed to play in the NCAA Division I football, because they do not have the same opportunities to profit from the name, image, and likeness of junior college, and therefore it's not unreasonably restricting them from trade or competition. JUCO doesn't allow for meaningful opportunities, the NCAA does, and preventing the X year could actually be discriminatory in the application for future students coming in. JUCOs are essentially a stepping stone for low-income students and first-generation students to receive a higher education and blaze career opportunities for themselves and their families later on down the line. This rule could be penalizing them. It can have a negative effect on the student who chooses to the transfer pathway from junior college to the NCAA college. And it's essentially setting up disadvantaged students for a lucrative career later down the line. And if there is, so opponents may say that there's an unfair advantage in the age gaps if they want to wait to apply to college, but we can tell those students to wait maybe a year for training, eating protein, getting stronger so that they can get accepted at a competitive college, and they'll be better prepared for the sport and for NIL opportunities later on down the line. Essentially, the NCAA waived the injunction allowing Pavia to play later on. They argued that the injunction was unnecessary, while the NCAA argued that the injunction was necessary. And Pavia maintained that the JUCO rule violated antitrust law by restraining competition among athletes at schools. Pavia insisted that appellate review would influence the court of his broader lawsuit, which sought to extend eligibility in 2026. The NCAA countered that, allowing the injunction to stand, and they were worried that it can bolden further challenges to its rules. Ultimately, both the NCAA and Pavia wanted to claim that their disputes fell into the narrow exception for issues capable of repetition, yet evaded review. In the end, Pavia won the injunction by the blanket waiver, and he was allowed to continue playing. And
okay, so the blanket waiver.
Mhm.
Should the blanket waiver, they then applied it to anybody in his situation last year?
Correct.
Okay. Do you think that blanket waiver should be put in effect for this year?
We're saying that it should be put into effect this year also, because it would put the hypothetical student
Yeah.
on a pathway that would give them NIL opportunities later on down the line. the student may be from a disadvantaged background, or he may be a first generation student. So it's setting him up for greater opportunities in the long run.
Let's say he's not.
Well, regardless of that, he would still be surrounded by football players that share his passion and
Mhm.
share his love for the sport also. So he would be benefiting in either way. And he's staying in school, he's doing something productive. for
Well, you
himself.
could also be getting your see, some of them you can be getting your master's degree.
That also
They could be in the middle of their master's degree.
yeah, and it's exposing him to a network of people who are equally motivated as he would. So it should still be allowed to pass in that sense. So in the meantime, he can get by college scholarships, and nobody would suffer any adverse financial damages. So we're arguing that eligibility should be that those years should not be included to allow them to play longer. So I'm gonna pass it on to Solina, who's gonna discuss the third portion.
Okay, so, school's position, some arguments we have for that is that
For what? Who are you arguing for?
that would make it against keeping it. I'm just trying to summarize it,
Okay,
at the school's position.
okay.
So the school would argue that the eligibility rules preserve scholarships,
Uh-huh.
and then also they give a fair opportunity for incoming athletes.
For incoming athletes?
Yes. So there's not like a stockpile.
Okay. Well, they can't stockpile them. You can only have 105 in football.
Oh, okay. Well, that's still a lot. I mean, wait.
No, I know, but so when you're talking about the scholarships, what do you mean?
Don't you have okay, I'm learning.
I
about
know
sports.
that. That's why I want clarity, because this is on a podcast and
Oh, okay, so from the school, they have a certain amount of money that they're gonna give to these students.
they're gonna have certain scholarships
Yes.
amounts for each sport. Each sport has certain scholarships. Basketball has a different amount than football, and football has a different amount than softball, and it's all different. Baseball is different than football. They all have a certain amount of scholarships each year, and you can't go over that.
Okay.
So I'm not quite sure where you're going with the argument. That's what I'm trying to figure out.
Okay, well, then scratch that argument right now.
Okay, why, what was gonna be your argument?
Well, I was under the impression that they hold that amount of whatever scholarship for that individual until they make their decision on moving elsewhere or staying.
Yeah, no, what's going on right now, which is really difficult, is the kids who have applied under the eligibility rule, under the Pavia case, are sitting waiting. These are football players. They're waiting because they don't know, am I going into the NFL or trying to pursue that? Or am I getting another year of eligibility? That's what Pavia's situation is. Am I going to play another year at Vanderbilt, or am I getting ready for the NFL draft? Okay, because if they sign with an NFL agent, an SRA, a standard representation agreement, they will not be able to play for another year, because you then mess up your eligibility. Okay, so you can't do that. You can sign with an agent that does NIL work for you, but you can't sign with somebody who is going to represent you in the NFL draft. So right now, if they applied, they are sitting there waiting for a response. Well, it's basketball season right now. So the basketball players who are applying for an extra year have priority over the football players. Now, the other issue is the portal's going on. So the portal just opened. And I think the portal opens. Jimmy, does the portal open in 2 weeks? Jimmy, do you know if the portal opens in 2 weeks, closes in 2 weeks? It started last Friday and it closes in like 3 weeks. So if they do get granted eligibility and they don't want to stay at the school where they are, they won't be in time to get into the portal. So these decisions need to be made. Okay, the process is you have to apply through your compliance department at your school and have them submit paperwork asking for another year of eligibility. And now what they're all doing is they're waiting for the NCAA to respond. And they haven't responded yet. Okay, so until they respond, the player, at least in football and even basketball, doesn't know whether he or she can play. So the scholarship part, and this is an issue also, each team only has so many scholarships. So they don't know, do I go get another player in the portal for this position, or is this person getting to come back? So it is kind of messing with things. Yes, Jimmy.
For all players in the FBS and FCS levels, it is closing on January 16th. However, for those involved in bowl games and postseason runs, it'll expand until the 24th.
Okay.
I'm unsure of how that affects the portal for D2 and D3 programs, however,
About the what?
the D2 and D3 programs.
Well, they're another group that has challenged under the Pavia case that they don't want their D2 rules to count because they didn't have an opportunity to make NIL money. There's cases out there on that too. So I just want to be clear with before, whatever you were thinking your argument is, that's what's going on right now currently, which is why there's just a lot of chaos because nobody knows. Nobody knows whether these players are going to be able to play or not. And how long can a team save a spot? And how long, you just don't know if they don't respond. Hopefully they respond quickly, but that's not what I'm finding is happening. Okay, so what else were you going to talk about?
My last point was that the rules are there to limit eligibility, not necessarily employment opportunities.
Mm-hmm.
And so they're still getting experience there. Yes, it's not necessarily on the NIL level where you can get that type of revenue, but it's still something.
Are you being an advocate for the student or are you being an advocate for the school?
And the school.
The
I'm just
school.
doing a lot
So
of-
you're advocating for the school.
Yes.
Okay. All right. Eleanor, I'm going to ask you a question. I know you called the attorneys for the Pavia case. What did you ask them and what did you find out?
I've only heard back from the Texas trial group.
Yeah.
They're out of Puerto Rico,
Puerto Rico.
where they're located.
Really? Oh, I didn't know that.
He just emailed me. I just asked you a very basic question, like, how are you framing the argument? And because I didn't understand. I also asked about how it works because we haven't really studied, or at least I haven't really studied anything about class actions. He said it's not really a class action, it's just an added a lot more plaintiffs, but Pavia is no longer.
Pavia is no longer a
I
plaintiff?
don't think so, maybe he didn't say that exactly, but
Okay.
because his case, like for him, it's moot, so.
Yeah.
He's not really, he wouldn't have standing, right? Because he can't show that he's being harmed by this.
But I thought he was appointed for another year. Isn't he, Brian?
I don't think he plans on playing for another year because he understands how much of this class action is a long shot. It's just the Sixth Circuit's already spoken on it, and so he's just on it because he's been the face of this since 2024. And so
Gotcha.
So the attorney I should just read it to you instead of trying to paraphrase, because all I do is self. They're all laughing. Okay, so I said. I'm wondering if you could help me understand the overarching arguments each side might make. So, for example, probably student athletes are hoping to argue that they should have the right to compete. Perhaps the NCAA feels that the appropriate boundaries need to be drawn so that 27-year-old students are competing on their 9th season of college sports against students fresh out of high school. And he said, you're close on a procedural posture. The case remains pending. The appeal of the ruling on the preliminary injunction was denied as moot, but not the case itself. There was an amended complaint with a few dozen plaintiffs, but it's not a class action. Just a multi-plaintiff suit with all plaintiffs seeking the same relief. It's hard to distill an antitrust case down to just one sentence argument, but essentially, the athletes are arguing that time in junior college should not count against the time they're allowed to play NCAA Division I football, because they do not have the same opportunities to profit from their name and likeness in junior college. I would say that NCAA is arguing that junior college years should count for junior college football players still play games against other colleges. But Rakesh, who's the opposing counsel, may want to rephrase that since he represents the NCAA. He did not respond.
Oh, the NCAA didn't respond to you?
No, Rakesh, who represents the NCAA.
Oh, I got you, did not respond. So the catch to it all, and this is summarizing it in a very, very simple way. They basically want a student athlete's eligibility to start once they sign a scholarship or maybe even a walk-on spot at a Division I or FCS school. And so your years at junior college are not going to count against your eligibility, period. Now, the question is, does it expand to D2? Does it expand to D3? You see, because there's a case out there
Where
on
we
that
draw
too.
that line.
Yeah, Jimmy, what's your point?
According to a couple of sports reporters, Pavia is intending to declare for the 2026 draft.
Okay,
However, the attorneys that represented him, which are the ones we were discussing, came in an argument during December trying to equate the current situation to the basketball rules where right now NCAA basketball is allowing draft declarees to return and play in college if they don't get picked up in the draft, or at least that's kind of oversimplifying it.
yeah,
But those same attorneys are now representing Langston Patterson, who is the linebacker at Vanderbilt,
yes,
who is now making the same arguments that Pavia did in his injunction in front of the same Judge Campbell, asking for preliminary injunction to play in the 2026 season. That is the case that is currently being headed by Pavia's previous attorneys, and then 24 other players, including, I think what was reported, the Tennessee quarterback, which is Joe, I'm missing that name. But yeah, so that's the state of that case.
okay, so. Now I want your opinion for all of you who have been studying the case. What do you think is gonna happen with this ruling? Do you think the player is gonna win based on the scenario I gave you? Or do you think the NCAA is gonna win? I think the colleges are okay with either one. That's what I think. I think the colleges, some it'll help, some it'll hurt, depending on if they think the player. Here's the thing, if they don't think the player is as good as another player, they might not want the kid to be granted an extra year of eligibility. You gotta know how coaches think. Right, Jimmy?
I mean, yeah.
I mean, I'm just saying, I think colleges kind of, their arguments are really not as essential here as the NCAA and the athlete. What do you guys think is gonna happen? Based on your research?
I think they'll allow the hypothetical student and also Pavia for the injunction to continue, but if there's way too many 17 and 18-year-old high school students who aspire to be part of the D1 school, and if a lot of teenage high school students who aspire to be in are harmed and damaged, then I think they might not allow the JUCO years to apply. I think it's going to be a process. It's not going to be solved in this year.
You don't think it's gonna be selfish?
Not in this year. I think they'll allow it to pass just for this one time, but if there's a lot of students who show the same pattern, then eventually they'll say this is becoming too much, and we're not allowing high school students to have a fair play into D1 school.
Okay, what do you think, Brian?
It's hard to not see and admit the issues that college football is facing in such a quick time period. So you have the transfer rule, and I'm pretty sure this year is about 3,000 transferees, which you've kind of turned college football into a minor league sports where you can transfer school, move for money.
Mhm.
The entire principle of the NCAA in college sports was student athlete. And so really, if you want to talk about opportunities, this ruling really only affects one sport, maybe two with basketball. Because the rest of the sports don't get money like football does. And so you've really turned this entire NIL problem. I'm all for students getting paid, but Arch Manning, the guy, quarterback for Texas, has already made more than his uncle Peyton Manning did after he played 5 years in the NFL. And it's just,
Yeah.
it's kind of amazing if you follow Peyton's career or any of the Mannings. And so the idea, I think the court will stay out of this. I think the court's not going to change the rule. I think the JUCO rule is a great rule for football. It does create kind of an equal opportunity for everyone. A lot of kids don't get to play football after high school. It's a very small amount. And so junior college really gives kids an opportunity to continue playing for 1, 2, or maybe 3 years. And for the kids that are a little more gifted, they have the opportunity to go play, Division I schools. And so based on what the Sixth Circuit said and based on a history of the rules working in the NCAA, I don't see them changing this. The NCAA has too many bigger issues.
Yeah, got it. Okay. What's your opinion?
Oh yeah, like I stated earlier, I think it's difficult to see if they're going to decide whether to allow JUCO rules to apply during this year.
Mhm.
I think they're going to allow, I guess like the Pavia case with the injunction to pass for the time being, but if there's way too many high school students who are being harmed and not allow that opportunity to do the transfer rule then I think they're gonna change the rule, but not anytime soon.
But the judge, once they make a ruling, it's a ruling and it's a federal case.
Right.
So you can't go back later and change it.
Well, I feel like if there's a large portion of students who are damaged on a large scale, then I think there could be, I guess, a retrial or another decision. But for right now, I think the status quo might be maintained.
What's your opinion?
I see both sides. The opinion is that they would extend eligibility because it does limit their economic opportunities.
Okay, so you think the eligibility thing should be like told in a sense. It's like they're not counting the 2 year.
Yes.
Okay, all right. Is there anybody else who wants to put your opinion? Eleanor, what do you think based on the research you've done?
I think based on the fact that the judge gave an injunction,
Uh-huh.
like they have to weigh the merits of the case
Uh-huh.
and say, this is what we think is, likely. I think based on the fact that they gave an injunction because they really see that there's an argument to be made, I think that they're probably gonna continue to rule for that case.
Okay, so you
But
think
we
that,
don't know.
I know, so you think that they'll grant an injunction and then they'll litigate it later?
Yeah.
Same thing.
Right, and then it went to the appeals court, and even though they, said, well, this, this particular whatever is good, they're still gonna continue. Case, I mean. I also think like if you look at the Obama case, and I think was that. When I was looking at this, there was an ALHON or some other case that we didn't talk about.
There's tons of cases out there.
Right,
Yeah.
but it seems like antitrust litigation is really entering the sports world here as far as, when you're looking at law.
Yeah.
And I think that, if they had a valid argument based on antitrust law, have a strong argument. Because that seems to be how it works. So.
Right, okay. Well, I think you guys did a really good job. Is there anything else you want to add? Anybody? No? Okay, well, I'm gonna stop the recording. And at least we got everybody's stuff in. Thank you.